I've said it before and I'll say it again. Next to a declaration of war, the most important job any U.S. president has is the selection of who will serve on the Supreme Court. 9 justices serving lifetime terms, given the power to interpret the Constitution, determine the fate of issues like gay marriage, abortion, desegregating schools, even deciding a presidential election. And with 2 justices over age 80, one in his late 70s, and a seat still open after the death of Antonin Scalia, the stakes are higher than ever. Appoint someone in their 40s, and they could serve through 10 presidents. Joining me now is a man who's argued scores of cases before that court. He's also a professor at Harvard Law, where he's taught and mentored the likes of Barack Obama, John Roberts, Elena Kagan, Merrick Garland, Ted Cruz. Obviously, this guy believes in diversity. Larry Tribe, it's great to see you.
Great to see you, Jim.
So I want to quote something from one of your students. Here's what he had to say. There's certainly long historical precedent for a Supreme Court with fewer justices. I would note just recently, Justice Breyer observed the vacancy is not impacting the ability of the court to do its job. That's a debate that we're going to have. That's your A student, Senator Ted Cruz. Does he know what he's talking about?
Well, he's smart, but he's also wily. He thinks that he should defend the party for having the Senate just abdicate its responsibility of filling that seat. Of course, the court is doing its job. It's doing its best. But on the most contentious issues, it's divided 4-4. And when it's divided 4-4, the result is that some lower court's decision, often conflicting with the views of lower courts elsewhere in the country, will have the last word. That's no good. An 8-justice court cannot be allowed to become the new normal.
If Hillary Clinton, president-elect, should she be, were to call you on the phone and say, I'm contemplating renominating Merrick Garland, what would your advice be?
Well, I think he would be a great justice. And I think that although a lot of people will be pressing her to select someone perhaps even more liberal and someone 20 years younger, I think that Merrick Garland deserves the most serious consideration. He's waited longer than anybody else in history, and he's a very healthy 67-year-old. I think he would serve with great distinction, and I would be strongly in his corner.
You know, speaking of Ted Cruz, I've seen you've seen the comment where he is, in addition to what I just read a minute ago, has said we're contemplating stopping all nominations of a Clinton presidency, and that was foretold by another student of yours, John Roberts. Here's what Roberts said 10 days before Antonin Scalia died. Justice Roberts, when you have a sharply political, divisive hearing process, it increases the danger that whoever comes out of it will be viewed in those terms. Is this ever going to be the same again?
It's hard to imagine. I mean, neither side is going to unilaterally disarm. Both sides are going to try very hard to have their philosophy of how the Constitution should be interpreted amply represented on the court. It's always been that way, but the country hasn't always been quite this polarized and philosophically divided, and I don't really see any way to get out of it. But I do think that grown-ups have to somehow play a larger role in the process, and there has to be some accommodation.
Who's that grown-up, by the way?
Well, I'm not sure at the moment there's anyone except perhaps, at least among the existing candidates, Hillary Clinton. And I think she will take into account when she names someone whether it's someone who could generate consensus.
Well, but Merrick Garland could generate consensus. You know better than Orrin Hatch, who obviously said one of the greatest justices, should they ever nominate Merrick Garland, long before the fact, no one would ever vote against them.
When they said that, they assumed that they were going to win the presidency and be able to name another justice far to the right. It's no longer likely that that's going to happen. And the idea of letting the court just whittle itself down by attrition is wrong. And it's also unconstitutional, though there's no court that could force the Senate to do its duty.
You know, speaking of the 4-4, I read a piece that I think you wrote. Obviously, people know you're lead counsel on Bush v. Gore on a couple of levels. And I know you've been, I don't know if appalled is the right word, you've been unhappy with Donald Trump's characterization of his concern about what might happen in the future with what happened in Bush v. Gore. And then you go on to say, compound that with the fact that a evenly divided court might end up having to make a decision in this case.
That would really be the nightmare scenario. I mean, if it ends up being so close in Ohio or Florida or Nevada or one of the battleground states that under the rules of that state you've got to do a recount the way Florida law required when 6 million votes were cast, and the difference between winning and losing was just 537 votes. If that happens, and if the matter goes to court, as it well could, the idea of the issue of how the votes should be recounted coming before a court that's evenly divided, I mean, it might well be that those 8 justices would be unanimous on what the right approach was, and I do think that they would step up to the plate and not just play the role of politicians in robes.
What was the vote on Bush v. Gore?
Well, it was 5-4.
So what, I was just going to ask the obvious question, if this was the 4-4 court in 2000, what would have happened?
Well, it depends on what the issue is. I mean, there are all kinds of ways that votes can be miscounted. I mean, if it turned out that there was clear proof, for example, that African Americans were being denied the right to vote in some jurisdiction, then I can see Hillary Clinton being the one who ends up contesting the result. But she and every other presidential candidate in our history has always said that when the dust settles and when the voters have spoken and when any judicial challenges are done, they will accept the result. It's outrageous and fundamentally dangerous to democracy for Trump to say, I'll hold you all in suspense. I mean, his whole theory that it's rigged is not based on any evidence about what's going to happen in this election. It's a kind of a priori principle. And if that theory, with maybe tens of millions of angry voters behind it, is coupled with the kinds of assassination threats that you mentioned earlier in the show, we have a formula for something that hasn't happened in this country since the beginning. It would be akin to a civil war. And I don't want to be, I don't want to be over the top, but this is really serious.
Do you know Trump?
I've never met the guy.
You've essentially called him what an ABA committee intended to call him until they were censored, ironically, sort of a libel bully kind of thing. And you've offered to represent for nothing if he actually ends up suing those
women
accusers.
who have accused
you represent
him.
those
and
women.
I would represent the ABA committee that he's threatened to sue, and I would represent anybody that he tries to bully. That's a technique that tyrants have used throughout history. Although I don't believe that one should ever compare anybody to Hitler, it is true that in the rise to power, Adolf Hitler used the threat and carried out the threat of suing his critics. That's a very potent threat when it silences critics who don't think they can stand up to this bully with all of his money.
We only have a minute left, Larry Tribe. There are a lot of 5-4 decisions that really matter. Heller, the gun case, first case that says an individual has a right to bear arms under the Second Amendment. Citizens United, Obamacare, even Roe v. Wade was 5-4, wasn't it?
No, it was 7-2.
7-2. Okay, so forget that for a second.
But Casey, which reaffirmed it in 1992, was 5-4.
So what has potential to be overturned, either under a Trump or Clinton? What could change dramatically?
Well, Citizens United could change dramatically under a Clinton presidency.
Even though it's fairly recent.
However recent, it was deeply contentious. And even if it's not overturned, it could be cut back so that it's far less dangerous to democracy. Decisions like Heller are not likely to be overturned. There will be an individual right to bear arms. But laws like the one in the District of Columbia that basically said if you've got a pistol at home, you have to have it in a safe condition.
Which almost no one talks about from that case.
That's right. But those were the facts. Laws like that could be upheld even though there is an individual right to bear arms. Basically, the court could uphold the regulation. Roe v. Wade would be on the chopping block under a court that Trump would help to populate. Affirmative action would be reversed under a Trump court. There are enormous numbers of things we take for granted that would be endangered.
I think you have to teach some more students really quickly, Larry Tribe. It's great to see you.
Great to see you, Jim.
Thanks so much for your time.
Thanks.
I appreciate it.